All right, welcome to the deep dive. Today we're pulling back the curtain on a topic that sounds, well, maybe a little dry. Suretyship and debt collection.
Yeah, sounds like something straight out of a law textbook.
Exactly. But trust us, it's actually packed with practical insights that touch almost everyone's life.
Yeah.
I mean, think about it. Have you ever co-signed a loan or worried about a friend's financial struggles maybe impacting you? Or perhaps you're a small business owner just navigating payments and stuff.
Right.
Our mission, like always, is to take these complex legal ideas from our sources and, boil them down into crystal clear nuggets of knowledge, make them really useful for you.
And that's precisely why this deep dive is so relevant. These concepts, they're kind of the silent architects behind so much of our financial world. Think about Sarah launching her candle business, needing that startup loan.
Right.
And her brother Mark stepping up to co-sign. Understanding these distinctions, it isn't just academic. It's really about protecting yourself and understanding where your money or, someone else's truly stands.
So let's unpack this with Sarah and Mark in mind. What exactly is suretyship?
Okay.
At its core, it's when one person agrees to be liable for the debt, or maybe the obligation, of another person. It's that financial safety net, kind of.
The backup plan.
Yeah. You've got three main players. First, the creditor, that's the bank, maybe, who loaned Sarah the money in our example.
Right, the obligee.
Then there's the principal debtor, or obliger, that's Sarah. She owes the original debt.
Okay.
And finally, the surety. That's Mark, who's agreeing to back Sarah up.
And here's where it gets really critical, especially for Mark or anyone in his position. We absolutely need to distinguish between a surety in the narrow sense and a guarantor.
Okay, surety versus guarantor. Why is that so important?
Well, it's not just legal jargon. It's the difference between immediate financial exposure and having a bit more breathing room. A surety, strictly speaking, is directly liable on the contract itself.
Directly liable.
Yes. If Sarah's loan payment is due June 1st, the bank can go straight to Mark on June 1st and demand payment. They don't have to call Sarah first. They don't even have to declare her in default. Mark is essentially on the hook the moment Sarah's payment is due.
So no waiting period for Mark. The bank just bypasses Sarah, comes straight to him.
Precisely. It's immediate liability. Now, a guarantor is different. A guarantor is only liable to the creditor if, and only if, the debtor Sarah doesn't perform her duty. Usually that means she fails to pay, she defaults.
Okay, so there's a condition there.
Exactly. If Mark were a guarantor, the bank could only demand payment from him after Sarah actually defaults on that June 1st payment. He's not on the hook until she misses it.
I see. And I think I read there's an even sort of more protected type of guarantor, the guarantor of collectability.
Yes, that's right. This sets an even higher bar for the creditor. A guarantor of collectability is liable only if the creditor is genuinely unable to collect from the debtor, Sarah, after exhausting all legal remedies.
Exhausting all legal remedies. What does that mean, practically?
It means they've tried everything. Demanding payment from Sarah, suing her, getting a court judgment against her, even trying supplementary proceedings to seize her assets. Only after all that fails could they come to Mark.
Wow.
So, for you, the listener, understanding the exact wording in any agreement you sign is just paramount. Are you a surety? Directly liable. Or a guarantor with some conditions. Or that rare guarantor of collectability. That fine print can make a huge difference to your immediate liability and risk.
Absolutely. So we've talked about these formal agreements, but what if you just, shake hands? Or give a verbal, yeah, sure, I'll back them up. You might think that's enough, right?
Yeah, you might think so.
Well, here's where we hit this really old legal principle, the statute of frauds.
Yeah.
And it can completely derail what seems like a simple promise.
This is a big one.
Basically, if you're promising to answer for the debt of another person, it absolutely has to be evidenced by some kind of written memo signed by you, the surety, to be legally enforceable.
Signed by the person being charged, yeah.
Without that piece of paper, that written proof, your verbal promise, generally unenforceable. It's like trying to build a house without a proper foundation. Just won't stand up in court.
Exactly. That writing requirement is crucial for these types of promises.
All right, so Mark has co-signed Sarah's loan. Let's assume he's a surety in the narrow sense, directly liable. That's a big commitment.
Yeah.
So what rights does he have if Sarah's business, runs into trouble and she defaults? It can't all be downside for Mark, can it?
Well, when it comes to Mark's rights against the creditor, the bank, it can be surprisingly limited, actually.
Oh.
Once Sarah defaults, Mark generally has no right to be notified of that default.
No notice. Seriously.
Generally, no. And the bank doesn't have to try and collect from Sarah first. They also don't have to go after any collateral they might hold from Sarah, like, say, her business equipment.
So the bank calls the shots entirely.
Pretty much. The bank has all the power here. They can demand payment from Mark immediately, or from Sarah, or go after the collateral, and crucially, they can choose any order they want.
Any order.
Yep. The only real exception, as we mentioned, is if Mark happened to be a guarantor of collectability, which, frankly, is quite rare.
Okay, so let's take an example. What if Sarah's business actually goes into bankruptcy? And the bank, let's say they have a mortgage on her factory as security. Mark could still be forced to pay the full loan amount immediately, even with that collateral sitting there.
Exactly right. Even if liquidating that factory might take months or even years in bankruptcy court, Mark can't force the bank to wait. He has to pay the debt in full.
Ouch.
Then, after he pays, Mark gets to step into the bank's shoes. This is called subrogation. He acquires all the rights the bank originally had against Sarah, including that mortgage on the factory.
I see. So he pays first, then tries to recover using the bank's old rights.
Precisely. The immediate and often direct burden on the surety is really significant. It just highlights why understanding your position before you sign is absolutely paramount.
Oof. Okay, so Mark pays the bank. Is he just out that money? Or are there ways he can try to get it back from Sarah? What rights does the surety have against the principal debtor?
Okay, yes. Thankfully, there are some clear avenues for Mark to recover from Sarah. There are three main ones to know.
Three, okay.
First, there's exoneration. Think of this like stopping the car before it crashes. Mark sees Sarah struggling to pay. Maybe he anticipates she's going to default.
Okay.
He can proactively go to court, bring what's called a suit in equity, and say, Your Honor, Sarah owes the bank. Make her pay the bank now so I don't have to. He's trying to compel her to perform her duty before he has to pay anything himself.
So, like a preemptive strike to protect himself. Got it.
Oh.
What if he does end up paying?
Right. If he's already paid, then reimbursement comes into play. This is sometimes called indemnification. So the car has crashed. Mark has paid the damages, meaning he paid the bank for Sarah's debt.
Right.
Now he can go directly back to Sarah and sue her, saying, okay, I paid your debt to the bank. Now you owe me that money back. It's a direct right to be repaid.
Exoneration is before paying. Reimbursement is after paying. Makes sense. What's the third one?
The third is subrogation, which we touched on briefly. After Mark pays the bank the full amount Sarah owed.
He steps into the bank's shoes.
Exactly.
Yeah.
He literally acquires whatever rights the bank had against Sarah. So if the bank had a security interest in Sarah's equipment, or maybe a priority claim in her bankruptcy.
Mark gets those rights now.
Yes. Mark now has that same security interest or that same priority, and he can use those rights to try and recover the money he paid from Sarah or her assets. These three rights, exoneration, reimbursement, subrogation, are how the legal system tries to, eventually make the surety whole again, even though they often bear that initial brunt of the payment.
Right. That helps clarify the surety versus debtor situation. Now, what if Mark isn't the only one who co-signed for Sarah? What if their sister Lisa also signed on as a surety? How do rights work when there are co-sureties?
Good question. Co-sureties are simply two or more sureties who are liable for the same obligation. So Mark and Lisa are both backing Sarah's loan. Critically, they are usually jointly and severally liable. Meaning the bank can go after either Mark or Lisa or both for the entire amount of the debt. They don't have to split it up.
Okay. So the bank can just pick one.
Yeah. Now, similar to the rights against the principal debtor, there are rights among the co-sureties. First, there's exoneration again. If it looks like Sarah is going to default and they'll have to pay.
Mark could sue Lisa.
Right. Mark could go to court and compel Lisa to pay her fair share of the debt to the creditor proactively, so Mark doesn't end up footing the entire bill initially.
Trying to share the burden up front. And then there's contribution, which sounds like it happens after someone pays.
Exactly. Contribution is the right that arises after one surety, let's say Mark, has paid more than his pro rata share of the debt.
Pro rata share. How is that calculated?
Okay, this is where it can get a little complex, but it's important. The default rule, if the contract doesn't say otherwise, is that you determine the share based on the number of solvent sureties.
Solvent sureties.
Right. So imagine Mark, Lisa, and another friend, David, all co-sign for Sarah's $30,000 loan. If all three are solvent, each is responsible for $10,000, 1/3. But let's say David goes bankrupt and can't pay anything.
Oh.
Now there are only two solvent sureties left. Mark and Lisa. So Mark's and Lisa's pro rata share jumps to 1/2 each, or $15,000. If Mark paid the full $30,000, he could only seek $15,000 in a contribution from Lisa because David is out of the picture financially.
Wow, so one co-surety's bankruptcy increases the burden on the others.
Significantly, your exposure can jump. Now, what if they had originally agreed to be liable for varying amounts?
Like Mark signed for $6,000 max, Lisa for $3,000, David for $9,000.
Exactly. Let's say the total debt Sarah defaulted on was $6,000 and Mark paid the whole thing.
What?
To calculate contribution, you look at their original maximum liabilities. Total is $6K plus $3K plus $9K plus $18,000.
Okay.
Mark's share of the $6,000 paid would be his proportion. $6,000, $18,000. $6,000, $2,000. Lisa's share. $3,000, $18,000. $6,000, $1,000. David's share. $9,000, $18,000. $6,000 equals $3,000. Mark paid $6,000, so he could recover $1,000 from Lisa and $3,000 from David.
So it's based on their original agreed limits, proportionally.
Yes. And if one, say Lisa, went bankrupt in that scenario, you'd recalculate the proportions just between Mark and David based on their $6K and $9 CAL limits.
Okay, that's complex but crucial. So what does this all mean for you if you're ever one of several co-signers? It's not just about the numbers. It's really about knowing the solvency, the financial health, and the commitment of the other parties involved. Your risk isn't static.
Absolutely. It's a dynamic situation.
Now, for the often surprising part, and sometimes the good news for the surety may be bad news for creditors, we've talked about the challenging realities that Mark might face. But surely there are situations where they're not just stuck, where they're actually off the hook entirely, right? What are those key scenarios, those sort of escape clauses where a surety is legally discharged?
Absolutely. There are several important defenses a surety can raise. One key defense relates to the principal debtor's situation. If Sarah, the principal debtor, was defrauded into the loan contract by the bank.
The bank misled her.
Yes. If the bank committed fraud to get Sarah to sign, Mark can usually use that as a defense against the bank. However, here's a twist. If Sarah lied to Mark to get him to co-sign.
Oh, so the debtor lied to the surety.
Right. That is generally not a defense for Mark against the bank unless the bank was aware of Sarah's fraud against Mark when they accepted his surety promise.
Interesting distinction. What else?
Duress upon the principal. Similar idea. If Sarah was forced into the loan contract under duress, like threats, and Mark didn't know about the duress when he signed on, Mark is generally not liable.
Okay.
Also, illegality of the principal's obligation. If the underlying loan between the bank and Sarah was for an illegal purpose, making the contract void, Mark's surety obligation usually falls away too.
Makes sense. What if the main debt just gets paid off?
Well, yeah, that's the most straightforward one. If the principal's obligation is discharged, meaning Sarah pays off the loan in full, or she tenders performance, offers to pay, and the bank refuses to accept it, then Mark is obviously no longer liable. The underlying debt is gone.
Right.
Also, if the bank formally releases Sarah from the debt, Mark is typically discharged too, unless the bank explicitly states in the release that it's reserving its rights against Mark. They have to specifically say they're still coming after the surety.
Okay. And what about Mark himself, his personal situation?
Yes, the surety's own incapacity or bankruptcy is a valid defense. If Mark was legally incapable of contracting when he signed, maybe he was a minor or adjudicated mentally incompetent, or if his debts are discharged in his own bankruptcy proceeding, that protects him.
Got it. Now, you mentioned contracts need consideration earlier. Mark probably didn't get paid to co-sign for his sister Sarah. Does that matter?
It matters a lot, especially the timing. Like any contract, the promise to be a surety needs to be supported by consideration, some kind of bargained for exchange.
But Mark didn't get anything.
He didn't need to, directly. For an unpaid surety, we call them a gratuitous surety. Their promise is considered to have consideration if they make that promise before or at the same time as the consideration flows from the creditor to the principal debtor.
Okay, translate that for Mark and Sarah's loan.
So if Mark promised the bank he'd co-sign before the bank actually gave the loan money to Sarah, or at the exact moment they gave her the money, his promise is binding. The bank giving Sarah the loan is the consideration that supports Mark's promise.
I see. The bank's action supports both promises.
Exactly. But, and this is critical, if Sarah already received the loan money from the bank and then, maybe a week later, Mark gratuitously promises the bank, oh yeah, I'll back her up.
Too late.
Usually, yes. There's no new consideration flowing from the bank at that point to support Mark's later promise. His promise might be unenforceable for lack of consideration. So for you, the listener, the timing of your promise, especially if you're doing it out of kindness for free, is incredibly important for whether it's legally enforceable at all.
That is a huge takeaway. Okay, what about changes? What if the bank and Sarah change the terms of the original loan agreement after Mark is signed on? Does that affect Mark?
Absolutely. This falls under the defense of variations of the surety's risk. And here, again, we distinguish between gratuitous and compensated sureties.
Okay, let's start with Mark, the gratuitous surety doing it as a favor.
For a gratuitous surety, the rule is very strict. Any variation of the underlying contract between the creditor bank and the principal debtor, Sarah, that changes the surety's risk even slightly will generally discharge the gratuitous surety completely.
Any change at all, even a tiny one.
Pretty much. The classic example involves a building contract. If the plan changes slightly, maybe making a parking lot a few feet smaller.
Even if it makes it easier or cheaper.
Even then. For a gratuitous surety, the courts often say, this isn't the deal they originally agreed to back, and any variation discharges them. The reasoning is they're doing it for free, so they shouldn't be held to a modified bargain.
Wow. Okay, so what about a compensated surety, like a professional bonding company?
Their standard is different. A compensated surety is discharged only if the change in the contract is material, meaning significant, and it increases the surety's risk of loss.
Material and increases risk.
Right. So in that parking lot example, making it slightly smaller probably doesn't increase the surety's risk, might even decrease it. A compensated surety likely would not be discharged by that kind of minor change. They're paid to take on risk, so only significant detrimental changes let them off the hook.
Okay, that's a really important difference. Now, what if the bank just gives Sarah more time to pay? Or they just, drag their feet on collecting?
Good distinction. If the bank and Sarah formally agree to extend the time for payment.
A formal agreement to change the due date.
Yes. Then the rules we just discussed for risk variation apply. Mark, the gratuitous surety, is likely discharged. A compensated surety is discharged only if the extension is material and increases their risk, which extending time often does.
But what if there's no agreement? The bank just delays. Doesn't push Sarah hard for payment.
If the creditor simply delays in collection without a binding agreement to extend time, the surety is not discharged. Mere delay or indulgence by the creditor doesn't let the surety off the hook.
Okay, so inaction isn't enough. It has to be a formal change or agreement. What if the bank messes up with collateral? Say they had a lien on Sarah's equipment but forgot to file the paperwork properly.
That's loss of security. If the creditor releases security they hold for the debt, or if the security is lost or damaged due to the creditor's bad faith or inaction, like failing to perfect a security interest by filing the right papers, then the surety is discharged, but only to the extent of the value of the security that was lost or released.
So if the equipment was worth $10,000, Mark's liability is reduced by $10,000.
Exactly. He's only on the hook for the remaining debt, if any, above the value of that lost collateral.
Got it. And one last defense. What happens if the bank releases one of the co-sureties? We had Mark and Lisa. What if the bank lets Lisa off the hook without Mark knowing?
Right. Release of a co-surety. If the creditor releases one co-surety, Lisa, without the other co-surety's, Mark's consent, it impacts Mark's right of contribution against Lisa.
Because he can't get money back from her anymore if she's released?
Precisely. Therefore, the remaining surety, Mark, is discharged to the extent that he could have recovered in contribution from the released surety, Lisa.
So in our earlier example where they were equally liable for, say, $50,000, if the bank released Lisa, Mark would be discharged for $25,000.
Correct. Because that's the amount he lost the ability to recover from Lisa. He'd still be potentially liable for the other $25,000.
Fascinating. Okay, so just to quickly recap the no defense situations we mentioned earlier, where a surety is generally still on the hook. If the principal debtor, Sarah, lies to the surety, Mark, to get them to sign, that's usually not a defense against the creditor bank unless the bank knew about the lie.
Correct.
And the fact that the principal debtor, Sarah herself, becomes bankrupt or incapacitated after the fact is also not a defense for the surety, Mark. He agreed to back her up, essentially insuring against that risk.
That's the essence of suretyship, really.
Okay, switching gears a bit. Beyond the specific world of suretyship, what other tools and strategies do creditors, like Sarah's bank, have when a debtor, Sarah, owes money and doesn't have enough funds to pay everyone? Because bankruptcy isn't the only path, right?
That's right. Outside of formal bankruptcy proceedings, debtors sometimes try a couple of alternative methods to deal with their debts, often with creditor agreement. One is a creditor's composition.
Composition.
Yeah, it's basically a negotiated settlement agreement. The debtor, Sarah, agrees with at least two of her creditors that they will accept less money than they are actually owed, as full satisfaction of their claims.
So everyone takes a haircut, basically.
Exactly. Once Sarah pays that agreed-upon reduced amount to those participating creditors, she's completely discharged from those specific debts. They can't come back for more later. It requires agreement, though.
Okay. What's the other one? An assignment.
Yes, an assignment for the benefit of creditors. This is different. Here, Sarah would transfer some or maybe all of her property to a trustee.
Like in bankruptcy.
Sort of, but it's usually a state law procedure, less formal than federal bankruptcy. The trustee then liquidates, sells the property, and uses the money, the proceeds, to pay off Sarah's debts as much as possible.
Did that discharge her from the unpaid part?
Critically, no. Unlike a composition or bankruptcy, the debtor, Sarah, is not automatically discharged from any unpaid debts just by making this assignment. The creditors haven't necessarily agreed to accept less than full payment. It's more of a liquidation mechanism than a discharge mechanism.
Okay, let's unpack this more. What about direct legal actions creditors can take? Things they can do through the courts to get their money, or maybe secure assets, even if they didn't have collateral originally?
Right. These generally fall under the umbrella of judicial lands and garnishment. These are powerful tools for creditors once the legal system gets involved.
Right.
First, sometimes even before getting a final judgment, a creditor might use pre-judgment attachment.
Before judgment. How does that work?
If the bank, for instance, is suing Sarah for the unpaid loan, and they have reason to believe she might, say, hide assets or sell property to avoid paying if they win,
Yeah.
they can ask the court, right at the start of the lawsuit, to issue a writ of attachment. This order allows the sheriff to provisionally seize some of Sarah's property.
Seize it. Just like that.
Well, there are safeguards. Usually there has to be a hearing first, and the creditor typically has to post a bond to cover potential damages to the debtor if the attachment turns out to be wrongful. But yes, the property is basically held by the court to ensure there's something there for the creditor to collect against if they eventually win the lawsuit.
Okay, that's pre-judgment. What happens after the bank gets a judgment saying Sarah owes them money?
If the bank wins the lawsuit, gets a judgment, and Sarah still hasn't paid, the bank can then ask the court to impose a judicial lien on specific property that Sarah owns and possesses.
A lien imposed by the court.
Right. The court imposes the lien and then typically issues another writ, maybe called a writ of execution or levy, directing the sheriff to actually seize that specific property and sell it at auction. The proceeds from the sale then go to the bank to satisfy the judgment debt.
Can they just take anything? Her house. Her car.
Good point. There are important debtor protections. Many states have laws protecting certain property from most creditors' judicial liens. The most common is the homestead exemption, protecting some or all of the value of your primary residence. There are often exemptions for essential household goods, tools of the trade, things like that, up to a certain value.
So they can't leave you completely destitute.
Generally, no. And this is a critical exception, these state law exemptions usually do not protect property from creditors who have a purchase money security interest, PMSI, or a mortgage on that specific property.
Yeah.
If you don't pay the loan you took out to buy the car, they can still usually take the car.
Okay. And any other big exceptions to exemptions?
Yes. The IRS. For unpaid federal taxes, the IRS can file a federal tax lien that attaches to all of a taxpayer's property, all property and rights to property. Even property that would normally be exempt from other creditors under state law, including your primary home.
Wow, okay, so the IRS lien is incredibly powerful. Now, what if Sarah's money isn't in property she possesses? What if it's, say, wages her side job owes her, or money sitting in her business bank account?
That's exactly where garnishment comes in. Garnishment is the legal procedure used when the debtor's property or money is in the hands of a third party.
Like an employer or a bank.
Precisely. Or even someone who owes a debt to Sarah, like a customer of her candle business. The bank gets a court order, a writ of garnishment, that's served on that third party, the employer, the bank, the customer.
And what does the order say?
It orders the third party, the garnishee, to turn that property or money over directly to the creditor, the bank, instead of giving it to the debtor, Sarah. And if the third party ignores the writ and pays Sarah anyway, they can be held personally liable to the bank for that amount.
Okay, serious consequences for ignoring it. Are there protections here too, like with wages?
Yes, definitely. Federal law, for instance, protects Social Security payments from garnishment by most creditors. And when it comes to wages, states typically have laws limiting the amount of an employee's earnings that can be garnished per pay period. Often it's capped at something like 25% of their disposable weekly earnings to ensure the person still has enough to live on.
So, again, protections against total destitution. Are there other specific types of liens we should quickly mention?
Yeah, a couple common ones. Mechanics liens and artisans liens. Under common law, if a mechanic repairs your car, or an artisan, say, frames a painting for you, they have a lien on that property for the value of their services as long as they keep possession of the property.
A possessory lien.
Right. If you don't pay, they can eventually give notice and sell the property to cover their bill. But if they give the property back to you before you pay, they usually lose the loan.
Okay. What about improvements to real estate?
That often involves immaterial manslin. This is typically for contractors, subcontractors, or suppliers who provide labor or materials for the improvement of real property, like building an addition onto Sarah's workshop. If they aren't paid, they must file a notice of their lien, usually with the local county recorder of deeds office, within a certain time frame. This lien then attaches to the real estate itself.
Now, sometimes debtors facing these collection efforts might try to get clever, maybe, and hide assets. What about things like fraudulent conveyances?
Ah, yes. A fraudulent conveyance or fraudulent transfer is essentially when a debtor transfers property away with the actual intent to hinder, delay, or defraud any of their creditors, trying to make themselves look poorer than they are, basically.
Okay, and if they do that?
Such a transfer is generally considered void or voidable. The creditor can ask a court to set aside the transfer, to disregard it, and allow the creditor to seize the property from whoever the debtor transferred it to, as if the transfer never happened.
How do courts figure out if it was intended to defraud? Debtors probably don't admit it.
Right. Courts look for certain badges of fraud, telltale signs that suggest a fraudulent intent. Was the transfer made to an insider, like a relative or business partner? Did the debtor keep possession or control of the property even after transferring title? Was the transfer kept secret or not disclosed? Was it a transfer of substantially all the debtor's assets? Did the debtor receive unreasonably little value or no value in exchange for the asset? Was the debtor insolvent at the time, or did they become insolvent shortly after the transfer?
So a whole checklist of suspicious circumstances.
Exactly. No single factor is necessarily decisive, but if several of these badges of fraud are present, the court is very likely to infer an intent to defraud creditors and set aside the transfer.
This really raises an important question, doesn't it? Why is it so difficult, generally, for debtors to successfully get away with trying to hide assets? It's because the courts and the law look for these very specific objective signs that strongly suggest what the debtor was really trying to do. Okay, finally, let's talk about a crucial piece of the puzzle, especially for you, the consumer listening: protections against abusive debt collectors. Because even when you owe money, you absolutely still have rights.
This is incredibly important. We're talking mainly about the Fair Debt Collection Practices Act, the FDCPA. It's a federal law designed to stop abusive practices.
Okay, FDCPA. Who does it apply to?
This is critical. The FDCPA primarily regulates the conduct of collection agencies, third parties, who are collecting debts owed to others. It also covers debt buyers who buy defaulted debts and try to collect them.
So third-party collectors. What about the original creditor? Like Sarah's bank calling her directly about her loan.
Generally, the FDCPA does not apply to the original creditor when they are trying to collect their own debt in their own name. There might be other state laws that apply, but the specific rules of the FDCPA usually kick in when the debt is turned over to a collection agency or sold.
Got it. So, assuming it's a collection agency covered by the FDCPA, what exactly are they prohibited from doing? What are these abusive practices?
The Act lists several prohibited actions. For example, they are severely restricted from contacting third parties about your debt, like your relatives, neighbors, or friends.
They can't call your mom.
They can generally only contact third parties to try and find your location information, your address or phone number. They cannot tell the third party that you owe a debt, nor can they identify themselves as a collection agency unless specifically asked. And they usually can't contact any given third party more than once.
Okay, what else?
They cannot contact you, the debtor, at inconvenient or unusual times or places. Generally, that means no calls before 8 a.m. or after 9 p.m. your local time, unless you agree to it.
Reasonable hours.
Right. They cannot contact you directly at all if they know you're represented by an attorney regarding the debt. All communication has to go through your lawyer.
Makes sense.
They absolutely cannot use harassing, oppressive, or abusive language or conduct. Things like threats of violence or harm, using obscene or profane language, or calling repeatedly just to annoy you.
So, no, pay up or we'll break your kneecaps.
Definitely not. Also, they cannot make false, deceptive, or misleading representations, like falsely claiming their attorneys or government agents, misrepresenting the amount you owe, or threatening to take action they cannot legally take or do not intend to take, like having you arrested for not paying a consumer debt.
That's a big one. You generally can't be jailed just for owing a regular debt.
Correct. Debtor's prison is not a thing for consumer debt in the U.S. And finally, they generally cannot contact you at your place of employment if they know or have reason to know that your employer prohibits such contacts.
Wow, that's a pretty comprehensive list of protections. So what power does the debtor have if a collection agency does violate these rules? What are the remedies?
Debtors have significant leverage under the FDCPA. First, you have the power to terminate contacts.
You can just tell them to stop calling.
You can notify the collection agency in writing that you refuse to pay the debt, or simply that you want them to stop all further communication with you. Once they receive that written notice, the agency must stop contacting you, except for very specific reasons, to tell you they're stopping collection efforts, or to notify you that they might invoke specific remedies, like filing a lawsuit, or that they definitely intend to invoke a specific remedy.
So written notice can basically shut down most communication. What else?
You have the right to sue the collection agency for violating the FDCPA. You can recover any actual damages you suffered because of their illegal conduct. Things like emotional distress or lost wages if you were fired due to improper contact at work.
Actual damages. Okay.
Plus, even if you can't prove actual damages, you can still potentially recover statutory damages of up to $1,000 per lawsuit. And if you win, the court can also order the collection agency to pay your attorney's fees and court costs.
That's significant, making it feasible to actually bring a case.
Yeah.
Is there government enforcement too?
Yes. The Federal Trade Commission, FTC, has the primary authority to enforce the FDCPA through administrative actions against collection agencies, forcing them to comply with the law.
So bottom line for you, the listener, you have real power against harassment and deception from collection agencies. Knowing these FDCPA rules means you can identify violations and take action. Those collectors must adhere to these specific protections.
Absolutely. Knowledge is power here.
Wow. Okay, what a journey we've been on today. We've really unpacked quite a bit, haven't we? Everything from those subtle but crucial differences between being a surety versus a guarantor like Mark co-signing for Sarah's business loan.
The timing and liability.
Right. To the really complex web of rights and responsibilities that kick in when money is owed, both through the surety and the debtor. And then finishing up with those powerful laws like the FDCPA that protect you from aggressive or unfair debt collectors.
It really shows how interconnected these concepts are. And understanding these sometimes intricate legal frameworks isn't just about, avoiding trouble or knowing the rules for the sake of it. It's truly about empowering yourself in basically every financial relationship you have.
Empowering yourself.
Yeah, which I think raises a really important question for you listening right now. How might knowing these details about liability, about defenses, about collection practices, how might that change the way you approach things going forward? Like the next time you consider a loan or think about guaranteeing someone else's debt, or even just making a significant purchase on credit, how can you use this specific knowledge to better protect yourself, make more informed decisions, not just for you maybe, but also for the people you care about?
That's a fantastic final thought, something really practical to consider. Thank you for joining us on this deep dive into the world of suretyship and debt collection. Keep that curiosity burning, ask those questions, and definitely keep diving deep with us.